to join somebody.
That's completely fine, Ben. So I'm just also sharing the YouTube live stream on. Uh, all right. I welcome you all on a panel discussion being hosted by the Center for Competition Law and Economics, titled "Competition in Digital Markets: The Remedial Phase." I am Sumit. I'm a director at the Center for Competition Law and Economics. Just a brief introduction about our panelists. We have Mr. Ben Holz de Payer, who is a case handler officer at European Commission Directorate General for Competition DMA enforcement team. Then we have Mr. Umar Hernandez, who is a coordinator general of digital markets at the Mexican Federal Economic Competition Commission. Then we have Dr. Shiva Shekhar, who is an associate professor at the Tilburg University. Then we have Dr. Reinhold Kessler, who is assistant professor for law and economics at the Dusseldorf Institute for Competition Economics. The panel will be co-moderated by Professor Nikita Shah, who is at Nirma University.
Hi, good evening,
Uh,
everyone. Sorry.
so I think the background of the discussion.
I think, okay, I'll take over from here. I hope everybody can hear me.
Yep.
Good evening, everyone. Good evening from India. I'm not sure what time zones everybody else is in, but we are in the evening time zone. And I will quickly give a brief. Hi, Sumit, can you hear us?
Hello, can you hear me?
Yes, we can. We
Okay.
actually.
Yeah, so I hand it over to Nikita to sort of give a brief background of the petition filed by the Department of Justice. Over to you, Nikita.
Thank you so much. A very good evening again to all the panelists. It's such a pleasure to be able to co moderate such amazing people on the panel. So, very quickly, to give a brief, and I will not take too much of the time, what we are discussing here is, and what is at the center stage, is the judgment given by the District Court of Columbia by Amit P. Mehta. And it's a very interesting judgment because they have essentially laid down four remedies in a broader way. First is to unfetter the monopolized markets from Google's exclusionary practices. They've told Google to open the monopolized markets to competition, remove barriers to entry, and not enter into any sorts of practices that excludes competitors from the market either by raising their cost, discouraging distribution, or depriving them of any sort of competitive access to inputs. Now they've divided the entire judgment in seven parts, which, with respect to what are the activities that Google LLC is not allowed to do. The first mandate that has been put on Google is to not foreclose competitors by contracting with third parties. Now, that also has a lot of elements. One of the elements is you cannot give any preferential treatment to anybody for using GSC or putting GSC as their search access points. You cannot give any sort of a payment to Apple to not enter or disincentivize Apple to enter into the GSE market. You are prohibited from entering into any sort of exclusionary agreements with the publishers. You cannot put conditions on the distributors to use GSE as a condition for any other Google product. They've also prohibited any sort of acquisitions without prior permission with any company that competes with Google in the GSE market or search text ads market. The second mandate that they've put on Google LLC is uh, to prevent foreclosure through ownership or control of related products. They've put four mandates in that. First is that they will have to divest with Chrome. The second, completely. The second is they have to divest with Android. Now, they have said that they can do a partial one or a complete one. It is up to Google LLC, but they have to divest Android. The third is they have been told not to self preference or frustrate, interfere, or limit the competitive abilities of the rival general search engine. And if they feel like any other structural relief they want to come up with after a few months, they also have kept that particular option open. The third very interesting thing that they've went ahead and said is to disclose all the scale dependent data, which is necessary for any GSE to compete with Google, which includes ads data, user side data, synthetic queries, Google search index data. The fourth is that they've categorically stated that Google is required to make available to a qualified competitor syndication licenses for a period of 10 years from the date of the license is signed, and make all the non advertising components of GSC, including organic results, everything available to the competitor. The fifth and the sixth, I'm going to just club them together and be very quick about it. They've told them to give all the search query reports and keyword matching to the advertisers, and as well as access to the data report. And they've prohibited Google categorically to not enter into any sort of a distribution agreement which limits or prohibiting them from pre-installing their browser, pre-installing default general search engine on non-Apple devices. And lastly, which is one of the most interventionist measure that I've seen, they have told them to get some committees on board, which includes a technical committee, internal compliance committee, anti-circumvention committee, which will have the government sitting on them to monitor their activities. With this introduction of the district court judgment that has been given by Amit P. Mehta, I would like to give the stage back to Sumit for focused questions.
Yeah. Thank you so much, Nikita, for giving a detailed background. So I first go to Ben. Ben, I think Nikita has already sort of summarized the petition filed by the Department of Justice. But just for the benefit of our viewers and the broad agenda which has been shared, if you can quickly sort of give a brief overview. I mean, what sort of separates digital markets from traditional markets? And then, of course, what I mean, once this sort of distinction is being made, I mean, what should be the sort of approach adopted by the competition authorities to sort of tackle these concerns? Ben, over to you.
Yeah, thank you very much, Samit. So look, so as I said before, so I'm Ben Hollister-Pyer, right? I work in the DMA enforcement unit at the competition authority here in Brussels at the European Commission. So obviously, one of the topics we wanted to cover today were kind of the differences, between sort of ordinary brick and mortar markets, let's say, and digital markets. And in that connection, what is the ideal approach to regulation? Obviously, this is something that's been a big topic for a long time, and it won't surprise anyone, I'm sure, that my view as somebody who works at the DMA enforcement agency is that a mix of traditional ex-post competition enforcement or regulation together with ex-ante regulation is probably, at least as far as we know now, one of the most effective models. I'm not saying it's perfect, but at least in Europe, we think this is going to help us to regulate the digital markets in an effective way, and we're already starting to see some results, right? So that's definitely something interesting that we can see happening already. So just look, I don't know if sort of everyone is aware of exactly how the DMA works, the Digital Markets Act in Europe. I'm not going to go into loads of detail because I'm aware of our time constraints, but just a few words on that, let's say. And I'm presenting it just because it's a model which seems to be at least preliminarily, let's say, working to a certain extent. And it's at the forefront of the regulatory approaches today. So, thank you for putting the slides up, actually. Sorry.
Yeah.
So look, just in a few words, right? So first, what is the DMA and how does it work? Okay. So basically, a few years ago, it was adopted, right, in 2022 and started applying in 2023. And it's just a regulation that applies to large digital platforms, okay? The aim being to ensure contestable and fair markets in the digital sector. So that's two things, right? Contestable and fair. Okay. It's obviously an ex-ante regime, and it complements antitrust competition law with the idea of trying to have an effect on prices, reducing prices and increasing quality, fair competition, choice, and innovation in the long term. So how does it work? Just so you know, so we define 10 types of what we call core platform services, right? These are services in the digital sector, kind of the usual suspects, the main services that are provided, like social networks, search engines, etc. Okay. And then we have specific criteria to designate companies as gatekeepers, right, in relation to those specific core platform services. Okay. Once we have designated a company as a gatekeeper, well, then a series of do's and don'ts, of obligations, basically kick in for those gatekeepers, and they have to comply with them. If they don't, well, of course, there we have a comprehensive remedies, fines, and even structural measures in certain cases that can be adopted. Okay. Just very briefly, a couple of slides back, if possible. Sorry for that. We have one more. Right there, yeah. So this is just so you can see what are the services that are covered by the DMA. Okay, the core platform services. We have, from search engines to social networks to online intermediation services, etc., right? And why do these services get covered by the DMA? And what are their differences with normal brick and mortar services? Well, you can see to the right some of the characteristics of these services, right? So we have scale economies that are extreme, strong network effects, lock-in, lack of multi-homing, vertical integration, and so on and so on. So those are some of the very specific characteristics of digital services that, in the European legislators' view, have warranted a specific regulation. Okay, so then just very briefly in the next slide, we designate companies as gatekeepers. There are two ways of doing it, quantitative and qualitative, but basically the bottom line is that a gatekeeper has to meet three conditions, right? So first, it has a significant impact on the market, then it provides a service that's an important gateway, and then it has an entrenched and durable position, right? So if those three conditions are met, well, then we can designate the company as a gatekeeper in relation to a core platform service. And then once that's the case, as I was saying, right, we have the do's and don'ts. So these are the obligations that apply to gatekeepers. They're very detailed in the DMA. This is just obviously an overview, right? But you can see a whole series of obligations that affect different elements, data, commercial relations, mobile ecosystems, and so on and so on. I marked in red those that are currently the subject of the ongoing remedies or enforcement proceedings. Okay, so there we have, as you can see, in relation to data, the ban on data processing, cross-use, and combination of personal data, and then in the other categories we have anti-steering ban, uninstallation, default, choice screens. And then an obligation, as you can see also to the right, to enable the installation use of third-party apps and app stores and so on. Anyway, there are a lot of different obligations. Don't need to go into all of them, but I'm sure you get the message. These are just, these obligations apply to companies once they've been designated. That's the idea, okay? So that's kind of how it works at the DMA level. And the jury's out on whether this will be the most efficient enforcement model or not, but this is the one we have. So
yeah. Thank you so much, Ben. I will come back to you on the European experience. Now I go to Professor Shiva. Shiva, any thoughts on how sort of this difference is being perceived between traditional markets and digital markets? And if the answer is yes, that there is some sort of distinction being made, I mean, how should sort of authorities approach this competition concerns in digital markets?
First of all, thank you, Sumit, for the invitation for this lovely panel. So let me quickly go into kind of one or two questions that you asked me, or at least that you suggested. The differences between brick and mortar and traditional and digital markets. When you say digital markets, I mean platform markets,
Absolutely.
because that would be my understanding. If that's the case, then there are a few differences, right? As already pointed out by Ben in his slide, the network effects that play out a big role, right? And we have the issue of winner takes all. And you could differentiate, but still platform markets, there's a dichotomy here, right? One that there is, what do you call this? It leads to one firm being dominant, but also dominance is not necessarily bad, because the whole idea of network effects is basically that the bigger the network, the higher the value that you have, right? From an economic perspective, in platform markets, fragmentation can lead to a bad outcome because you lower the value of network effects. So we just have to keep that in mind. That is different from traditional markets where dominance in itself was bad because it could lead to different outcomes. But here, Dominance may not be bad because it creates agglomeration, which can lead to higher value being created. So that's my, kind of one of the things that might be good to keep in mind. Also, some traditional ideas of how we understand, how economics works and competition works may change in, kind of platform markets. A good example is price discrimination between, competing for, or price discrimination can actually lead to better improvement, may lead to higher may even lead to Pareto improvement in platform markets because it can connect multiple markets together, right? There are spillovers across markets that can lead to better outcomes. Those were thought not to happen in traditional markets in some cases, in most cases, right? So that's where the economics shifts a little bit, and that's all we have to keep in mind when considering these markets with respect to traditional brick and mortar stores. Thank you. I guess that's my short spiel here. Yeah, thank you.
Yeah, so Shiva, I think there is a lot of food, but I'll come back to you. Umar, if you can sort of have the opening remarks and also sort of briefly sort of mention how Mexican Competition Authority is looking into this, given that you're specifically looking into the digital markets. Over to you, Umar.
Thank you. Let me start by a real quick disclaimer that my participation in this panel does not represent an official position by COFESE, the Mexican Antitrust Authority. It's all academic, as the rest of the colleagues. Second, I'd like to thank the Center for Competition Law and Economics for the organization of this panel and to you, Summit, for the kind invitation to participate. And yeah, going to framing the issue, as the other panelists have just mentioned, digital markets are highly dynamic. Consumer needs are constantly changing, and digital services must adapt quickly. And this rapid evolution of digital markets is leading us to a lack of consensus on how to address challenges posed by digital markets. And all these characteristics, particularly how dynamic the digital markets are, require us to rethink how we analyze transactions that may impact competition and the market functioning. And more importantly, we must also reconsider the role of competition policy, competition law, and what role should it play. So I made my participation thinking of to see, first of all, the balancing between regulation, competition, and innovation, what we have been studying from the Mexican perspective. And then when I come back in the second intervention to speak specifically about the Mexican model and a relevant case that we just proposed some remedies to digital markets. But to start between this need of balancing between regulation, competition, and innovation, we have seen an increase in regulatory activity all over the world with digital markets as the primary focus. However, as we all know, regulation often struggles to keep up with market evolution, making it essential to strike this balance between the tension of regulation and innovation. Excessive regulation, or the main argument is that it could hinder innovation, it could limit the potential benefits of new technologies, while on the other hand, weak regulation might be ineffective in achieving its intended goals and addressing dominance of large tech firms, these big tech. So what we see is that there is a need of policies that are, on the one hand, flexible enough to keep pace with innovation while promoting competition and providing legal certainty to all undertakings. And in jurisdictions where ex-ante regulation has been implemented, such as EU, UK, Germany, I mean, these debates have emerged over these tensions between competition, compliance, and innovation. And the recurring argument is that big tech companies delay the launch of new products and services in these jurisdictions that have this stringent ex-ante regulation, the so-called Brussels effect. Another factor that we have observed from Mexico is that the efficiencies that could benefit consumers, I mean, not all actions by these big tech are harmful, even though initially they might seem anti-competitive. So coming back, I mean, competition policy, as we see it, must remain flexible when assessing conduct under the rule of reason that we have also in Mexico, allowing practices that generate more efficiencies than harms, specifically seeing it for end consumers. And we as authorities face the challenge of defining the best approach to either updating the laws if we have to reform, or designing new ones to prevent large big tech from abusing their power. We have to understand market operations, and firm behavior will allow us to design these appropriate regulations rather than simply adopting models from other jurisdictions that may not be optimal in all cases. So I'll let it at there, and I might come back later to the Mexican example. Thank you, Samit.
Thank you so much, Umar. Now I come to Dr. Reinhold. Reinhold, if you can share your opening remarks. Also, if you can sort of cover how behavioral economics specifically, since Düsseldorf Institute of Competition Economics is working a lot on that, gives insight on the remedial part, and of course combined with highlighting this distinction between brick and mortar and digital markets.
Oh, thank you very much again, also for inviting me and having me here on this great panel. And let me also say that I have nothing to disclose in the matter of this conference or this somewhat event. And I guess it's now a bit hard to make out even more differences between brick and mortar and digital economy, since all the panelists already got some. But let me briefly share light on two things that may also be important for the later part on Google Chrome, because I think two aspects that are different, vastly different between the offline and the online world is first, so digital platforms bring together different user groups and they enable interactions, but they also control these interactions. And I think one way is also by steering specifically users to specific offers of the platform. And so this has been documented by a vast series of empirical studies for different kinds of digital platforms, which showed the power of rankings and also the power of just highlighting some products more prominently than others, highlighting certain services more prominently. So really having this platform control aspect, like also related to the self-preferencing part that we heard before, is one thing that is really distinctively different. And the other part is really that in brick and mortar economies, we typically have prices, and in the digital world, we often have no prices or like reduced price. And some of the other aspects is then we give away data, or the users actually give away data. And this is somewhat also the asset in the market. And we have seen also empirical studies there that this is a competitive advantage if you have access to data. Also for these new upcoming technologies, also the data is key for these kinds of innovations. And so giving access to certain user data, we also heard it already in the remedial part. These two aspects, like data and the level of steering, I think is what separates and what makes it difficult to capture really this in a regulatory framework now. And I think this is also where this ex-ante regulation somewhat hints at to somewhat look into this market and see where are the problems and somewhat try to somewhat find particularly emerging problems. But I guess the question there becomes whether you can really identify the full spectrum of business models, and you can somewhat also capture somewhat the problematic parts of it, especially for upcoming technologies. And in this way, sometimes it may become a bit vague in terms of what you expect from companies, and they can then in turn somewhat play along this and have some leeway in the implementations. And then it's really key to have these non-compliance measures that we already saw coming really quick. And I think this is now maybe also a good transition into the second line of questions that you sent us.
Yeah, thanks, Reinhold. Nikita, do you have anything specific to ask, or should I proceed?
Can proceed here. There are lots of things to discuss in the remedy part. So let's keep
Okay.
that.
Okay. Ben, I come to you. One question I have is that, when we talk about Digital Markets Act, even the slides which we just saw, when you talk about, stopping bundling, tying, or let us say self-referencing, where interoperability sort of serves an exception. What do you think that all these sort of provisions are mostly in terms of prescribing these big tech entities what not to do? To put it in other words, what interoperability do sounds very interesting to me, because it not only sort of puts a negative ban, but it also sort of puts a positive implication on basically entities which are operating in digital markets, right? I mean, for instance, European Commission recently opened consultation on interoperability in the case of Apple, right? So when it comes to sort of promoting competition in digital markets, do you think that apart from just sort of banning certain kind of activities which has resulted into various kind of harmful effects, is also requirement to sort of for the government to intervene on a positive basis? An example of it could be interoperability. Ben, over to you.
Yes. So look, I think interoperability it's a great example actually, because we actually have two proceedings open right now on interoperability in what we call specification proceedings at the DMA, right? So just for background, specification proceedings are proceedings in which the aim isn't to detect the existence of non-compliance or violation of the rules, but rather to specify in a positive way, a bit sort of along the lines of what you're saying, what are the measures that should be adopted by a company in order to come into compliance with a specific article of the DMA. Right. So, we have one article, which is Article 6.7, which, it creates an interoperability obligation, right? And then, for instance, so, iOS, right? Well, Apple, different companies have to comply, obviously, with this norm, but, one of them is Apple. And you probably saw just before Christmas, there was a whole catalog of different measures that was published, okay, which were measures that Apple should adopt according to the Commission on a preliminary basis in order to come into compliance with its interoperability obligations, right? So that, in a sense, that's a kind of sort of positive way, right? It's not just a prohibition; it's a positive way of setting out measures which should be adopted in order to come into compliance with the norm. And this is done in a fairly cooperative manner with the platform, right? It's in a sense we see it as we're helping the platform to come up with the measures that it needs to adopt in order to comply, right? And there, well, I mean, I think, look, we have a large number of measures, right? And basically, these measures, I mean, just to say, this is preliminary still, because these proceedings haven't finalized. They will finalize in a few months. Okay, and these were just published for the purposes of public consultation. But you'll be able to see there that we have a whole series of digital measures that essentially aim to ensure that devices, physical devices such as smartwatches and so on, which have been created by not by Apple but by third parties, have interoperability with iOS in the same way as Apple's devices have interoperability with iOS, right? So I think I'm replying to a question. Please let me know if I'm not exactly, but that's what I mean, right? These are sort of positive regulation in order to come into compliance with positive measures, not just prohibitions, right? So that's kind of how we see that there.
Yeah, absolutely. I think you're able to. This is exactly what I wanted to ask. Shiva, your thoughts? I mean, in the sense that it is very frequently repeated that the purpose of competition law is to sort of save the competitive process and not the competitors. But the question ultimately also comes that the ultimate obligation which you impose, right? If let us say even after sort of imposing ex ante regulations or ex post or sort of a combination of both. But if the ultimately sort of ecosystem is still remains captured by a couple of entities, right? So have we still sort of done enough when it comes to promoting competition in the markets? Shiva, on to you.
So thank you again for this question. So I must admit, I don't know whether we have done enough, but rather for me, and to be honest, for me, dominance in itself is not a problem. The problem comes is when it lead to some bad behavior, right? Some outcome that can hurt. As I said, in platform markets, dominance itself is not bad. It can lead to higher surplus, right? As an economist, you have to look at it in that direction as well, right? So having said that, all I can tell you is that seeing a lot of this flurry of regulation that I see, in Europe, I'm very happy that this is happening, but also I'm worried that there might be a lot of approaches that are ad hoc and not necessarily economics based, where you may have a lot of positive regulations that are trying to encourage someone to do a certain type of behavior, but to get a certain outcome. But let's put it this way: the goals of a policy may not be aligned with the realized outcome. Like you can do a lot of simple research and you can just show that it may not happen. And a good example of this is that suppose if you create interoperability between messenger services, that has actually been encouraged by EU, and you can easily show that the incentives of the firm that is collecting, that is data, interoperability between messenger services can lead to higher incentives to collect data. So depending on what your goal is at the end, if your goal is to just have a bigger mass and not necessarily protecting consumers' privacy or consumers' interest or maybe something else, they may not be aligned, right? So just the fact that you're allowing interoperability, maybe if it's not aligned with the goals of the realized outcome is not aligned with the goals of the regulation, then there's some sort of problem, right? And that's all I'm just trying to say. I'm just trying to say that every regulation must be spent, so there must be more time to be spent, to be discussed on what could be done to make sure that there's optimal implementation where there's alignment of the goals and the realized outcome. That's all.
Yeah. Nikita, you want to take it?
Right. Professor, I just have one question in the light of the Google remedies that these people have brought out. Um, when I look at the judgment, it makes me wonder, aren't we more focused? Shouldn't we be more focused on addressing actual harm to consumers rather than just harm to competitors in the antitrust cases? Because from the judgment that it looks like, it the user has a better experience or an improved experience with how the digital markets are functioning at the moment. But when it comes to the judgment, it seems like these people are only addressing the competitors and not really looking at consumer welfare in any aspect. What do you think about that?
So you're asking me, or okay?
Yes, I'm asking you, Professor Shiva.
Sorry. Okay. So you can just call me Shiva first. So and so I think it's from my perspective, it's more complicated because um, the EU, at least the Google case, you're right that currently we are having a good time, but it may happen in the future that at least so I can only speak to the ad ecosystem. I don't know other aspects because I don't want to bullshit around other things which I don't know about. But I can tell you in the ad ecosystem, merger, vertical integration by Google in the whole stack can lead to an outcome where Google has an unfair advantage compared to other intermediaries, which is quite easy to show that will leads to a higher ad tech tax, which then hurts. Again, when you're talking consumers, what are we talking? Are we talking about the publishers, or are we talking about the final consumers? Because in publishers are actually consumers of Google's ad tech exchange, and if they don't have if they're being taxed heavily because someone is so dominant in the whole stack, then that means that they don't have enough money to invest. They're not able to create better products. They're not able to do many other things. So we should just keep in mind that in some cases this, let's call it, agglomeration can be good, and here at least in the ad tech market, the vertical integration leads to a situation where Google has the ability to extract more money, which can actually in the end hurt consumers in the long run, right? If you have more competition within the each layer of ad tech market, then most of the monies are given to the publishers, and consumers, advertisers, everybody benefits. That's all I'm just going to say. But obviously, the only way to do that is to allow data, kind of access to other intermediaries who are competing with Google. But that will obviously, kind of contradict with some privacy laws. So
Right.
again, here I'm just going to stop soon. That I'm just going to say that we should also keep in mind how policy laws or regulations are mixing with our competition laws, and so these all have to be kept in mind when deciding. So I spoke about the ad tech market. I don't know others. I hope that's fine. Thank you.
Absolutely. Thank you. Sumit, you can take over.
Yeah. Umar, so my question to you is that you spoke about sort of making a balance between regulation and innovation, right? So I just want to understand that, on one side we have the European system where, it's mostly administrative. We have already seen an enactment of law. Ben has already spoke vividly about the same. But on the contrary, we also have the US, where no sort of legislative initiative has been taken. However, in the order in which the DOJ has filed a petition, a full case of contravention has already been found. Google has been sort of proved to be monopolizing in the market, and in the search engine market, or be it in the search advertisement market. So I just want to understand from you better that when it comes to Mexico, I mean, how is sort of Mexico proceeding on this? I mean, it's mostly on the administrative side or on the judicial side?
Thank you. Excellent. Yeah, that's makes sense, no? To see how can we actually land this and make it make sense for other jurisdictions. So in Mexico, what we have done is, of course, we have followed what's been happening in the EU with DMA way back from its proposal and initial discussions when they were at first analyzing what was then called the new competition tool. And this shares certain similarities with an article for competition law in Mexico that we have that give us certain flexibility to analyze markets by itself. It's not necessarily analyzing undertakings and seeing if they're dominant or not, but we can have a look at the markets and determine if there are barriers to competition, barriers to entry, and from there, then we can impose remedies. So this transition from the initial approach of ex-ante regulation framework, and it's then, well, now entering into force in the EU. I mean, this has marked a significant shift in how competition issues in digital markets are being addressed. So we have a lot of experience from abroad that we can see how it's going on, and before taking a step here in Mexico, suggesting to our legislators to actually enact these ex-ante regulations. So as I was saying, since 2020 at least, in Mexico, we have been monitoring different proposals in the EU, but also UK, Germany, US, Japan, etc. And I mean, what we see is that the key challenge remains assessing the necessity and also the feasibility of these proposals in the Mexican context. What we have in Mexico that makes it slightly different to other jurisdictions, but we share this with also many other jurisdictions in the world, it's internet penetration levels, for example, remain relatively low outside of urban areas compared to other countries. Digital literacy, or in this case, illiteracy, as a portion of the population still lacks necessary skills to use technology or primarily engage. Nowadays, they mainly engage in it for entertainment purposes, for example. Also, security mechanisms in digital environments, which are essential for fostering greater trust in users to go digital. On the other hand, we have seen in Mexico that digital services have introduced competitive pressure in markets that were brick and mortar, traditional, let's say. So ride-hailing platforms are challenging traditional taxi services. Fintech services are competing strongly with traditional banking institutions. Streaming services are disrupting both free TV and also pay TV sectors. So we're seeing this digitalization also in the Mexican market. And in certain cases, the entry of digital mavericks into specific markets it's fostering the competition, giving users more choices in improving overall market dynamics in Mexico. But still, I mean, this natural trend to go digital is moving towards regulation. That's no different to other jurisdictions. We see many proposals. I mean, almost once a month, a new proposal okay, it's time to regulate digital markets, AI, and so on and so forth. So in countries like Mexico, I mean, we have to approach this carefully, or that's the position by the antitrust authority, ensuring we have this whole perspective that on the one side, it fosters a comprehensive approach to digital markets and to continue bringing competition to it, but also to have a good look at competition and what's going on, if there's dominance, if there's abusing of this dominance. So one potential solution that we have to this problem or dilemma that we see is some hybrid regulatory approaches, which might combine substantive rules, competition law principles, so the classic exposed stance, traditional regulatory mechanisms for the actually sector regulators that might intervene in this framework. And this could also involve behavioral and structural remedies that we have this tool already in the Mexican law. So we have, again, coming back to the start of my intervention, we have this tool in our competition law that allows us to study the markets, to determine that if there are barriers to competition, that's how we call them here. And from there, even though it's not a trial or a mechanism against a particular dominant firm, we can impose remedies to these firms to allow competition in the markets. So if we have time later, I can tell you about a specific case that we have going on with this mechanism. Thank you, Samit.
Yeah, thank you so much, Umar. Reinhold, your thoughts on a difference between positive implications and negative obligations, one, and also there is a question from our viewers. How this sort of entire discussion takes shape in developing countries, like, for instance, say India, or even, let us say, to countries like Brazil.
Very good questions. Maybe starting with the first one. So I guess we are still also talking about this very Apple-specific obligations that were now somewhat released just before December. What I really like about this is to be more specific on how these companies come to compliance. I think this is a good step forward, because I also think that some of the obligations in general, you could somewhat debate about the leeway gatekeepers had with regards to the implementations, and also some ramifications when we saw that Google somewhat in Europe somewhat hit Google Maps whenever you typed in, I don't know, Berlin and some restaurant. And so in this regard, I think being a bit more specific with regards to these obligations is really good. Also, then you somewhat also be somewhat shy from these circumvention techniques that these platforms have. If you are somewhat in a cooperative manner, talk about these obligations and come to an agreement after also consulting also with third parties. So maybe on that, it somewhat also relates to my previous point about maybe some vagueness that is somewhat important for this upcoming digital business models that you cannot foresee in some regards. And so this may be about this. And regarding the developments in other countries, I had the pleasure also already with people from India in the I think it was about the Digital Competition Act as well, where these European rules are really seen as somewhat an experiment. And I think it's also very, I guess, good, because these digital markets are global and have a global nature, that there is also somewhat an international harmonization of rules. And so seeing what works or doesn't work and talking about it globally is, I think, a very fruitful. And that's why I'm also very happy to take part in this panel today, to just talk about what kind of learnings do we have about these new ex-ante regulations that we have now in Europe. And I think this is something that we would need strive for, that we are somewhat also really talking about the pros and cons of these types of interventions.
Yeah. Nikita, do you have any question to ask, or should I proceed?
I had a question to Ben, actually. So, how will the EU DMA strike the right balance between fostering competition and avoiding overregulation? Because from the remedies that I'm looking at, I feel like they're extremely micromanaging the way the companies are functioning. And that is essentially taking away their innovation. For instance, the DOJ in the Google case said that you will not be allowed to invest, or you'll have to take permission before you invest in any AI technology. And you'll have to divest your investment if you already are invested in some of those. So, how does this really work out with the DMA, and how would you stop yourself from over regulating?
Yeah, that's actually a really important question, which obviously has to be assessed when we're adopting an ex-ante regime. So just a couple of notes, because also before I think it was Omar, I think mentioned this tension, right, between competition, innovation, and regulation, and so on. And obviously there can be a tension there. But just one thing in relation to the DMA, right? There's been a lot of talk at moments of companies maybe delaying the introduction of certain features and so on in Europe because of the DMA. But let's not forget that innovators are not only big tech, large platforms, right? There are a host of other different actors that can innovate, right? And those are precisely those actors that are protected by the DMA, right? So the DMA is empowering to a large extent, business users of different types, developers and so on, as well as end users, of course, but a lot of businesses to be able to freely develop products, to freely innovate, so on. So so that's just to say, right? Let's not forget the other side of innovation, the other companies that also innovate. So that's one thing. And then the second thing is, there's a question as to, does the DMA really, stop or make innovation more difficult? Well, some companies may have said that they believe that is the case. Respectfully, I mean, my position is that, the DMA doesn't really stop anyone from innovating. What we're trying to say is, play fair. You can innovate, but play fair, right? And so, for instance, I don't know, Google Maps. Nobody's saying that Google cannot innovate on Google Maps. The only idea is, Google don't on Google Maps or use Google Maps in order to, say, self-preference your own services, right? So again, we're just trying to, we're not trying to stop anyone from innovating in Europe. But that's not what the DMA is doing. I don't think it's definitely not the purpose. It's, in my view, definitely not the effect, but rather just trying to create a level playing field where everyone can innovate, right? And just lastly, on the specific measures and the micromanaging and so on, I mean, I won't take a position on the measures that were proposed in the proposed final judgment in the US. But when you look, for instance, at the specification measures, right, that we have in Europe in relation to Apple, which again I would stress are only preliminary because they have not been, the final ones haven't been adopted, right? But when we look at those measures, really, the idea of these measures is not to really stop Apple from doing anything, but rather from enabling others, right, to also be able to interoperate with Apple and to be able to compete on an equal footing, right? So again, I don't think Apple's being, cannot innovate, but we will enable a load of other people, a load of other companies to innovate and to bring very interesting products to consumers, right? So yeah, that's basically the bottom line in how I see it.
I just have a follow-up question. I'll be extremely quick. When you say that you're trying to facilitate, or the DMA is trying to facilitate, what one thing I feel you could or your opinion on that, if suppose, for example, I have a pre-installed app which makes my life way easier, when you give other innovators the opportunity and tell Google not to be a pre-installed app, or give us an opportunity to have default search engines, multiple of them in our in the laptop, that only my user experience really degrades. So when you're trying to enable the other innovators to come into the market, are you really looking at ensuring that user choice is also maintained? How do you balance that?
I mean, I think that defaults and search engines is a very good example, right? So one of the measures that is obligatory under the DMA is to give consumers or users the opportunity to choose what their default search engine should be, right? So again, here we're not obliged. Nobody who really wants to use Google is obliged to use a different search engine, right? That's not the idea. Rather, different consumers, every consumer can have has a moment where they can make a choice, as to which they want their default search engine to be, right? So if they prefer to use Google, well, they're obviously more than welcome to continue to do so. They just have to press on, Google and when they get the choice screen, and that's that, and everything's fine. And like always, right? But if somebody wants to have another choice and to try something else out, well, they can also do that, right? And by giving that option to consumers, we're also empowering those providers of those other search engines and enabling them to enter into the market, or to at least consolidate their position a bit more, because they're having more exposure to end users, right? So again, the DMA is not really stopping people from using their preferred services, in my view. So I don't think there's a massive problem from that perspective.
Thank you. Sumit, you can take over.
Yeah, sure. Shiva, I'm interested to also know that, while a lot of conversation when it comes to the remedial side is on the Digital Markets Act, but very interestingly, the most drastic sort of measure, which is to sort of break up the entity, right? As sort of Nikita mentioned in the start, where Google has been sort of, DOJ is sort of petitioning the US District Court that Google should mandatorily disinvest in Chrome, comes in the US. Right. So how do we sort of make sense of this sort of dichotomy that, even though this was just one recent case in the US in the big tech space, however, due to the inherent nature of sort of judicial proceedings in the US, arguably United States was able to sort of get into better fact finding, which now is sort of resulting into this petition, which is where the proposed remedies are even more drastic to what are being proposed in the Digital Markets Act. I mean, your thoughts on it?
So I must admit that for me, I think okay. So regarding breaking up firms, I think this is too invasive from my perspective, right? We could always find behavioral remedies to arrive at the same outcome, perhaps. A simple example is if you which is happening already in, I think, in Europe, where Google's advantage through data can be limited because of its vertical integration, or let's call it even conglomerate integration across different markets, can be limited by just allowing someone else to have similar access to data, right? We don't need to break them up to get the same outcome, at least from my perspective. So when we're comparing competition, or when we're trying to break up, we're hoping that each of these entities are going to compete with some other entity in the same level. We could do the same just by giving access to data, right? By offering, so as Ben said, creating a, let's call it, a level playing field. How can you do so? In different ways. We don't have to break up and create invasive measures, because invasive measures, I don't know, maybe they may actually lead to outcomes where firms are not willing to now vertical integrate or create other issues, right? Because there is value in vertical integration. There is, that's the whole point. In vertical integration itself, at the European Commission itself, and there is in the vertical guidelines, there is actually an efficiency argument that's allowed, which there is a value in it. It allows coordination, it allows many things. And if we just break up every firm, or at least big firms, I think we just have to think why we are doing it. Is there something else that we can do? Breaking up should be of last resort. It should not be that first instance something comes up, let's just do it. From my perspective, it is that if we can find ways to create, to avoid being as invasive in the market, let the market go ahead and just give more of a, equal, or equal opportunities to smaller players. That would be the best outcome from my perspective. About the dichotomy, I don't have much answers. I don't know what's going on in the law, kind of what's happening in the US. It's also partly politics, I believe. As an economist, I can just tell you that, we can find other ways to, I think we should be able to find other ways to ensure, equal opportunities for other players in the market. Thank you.
Yeah. Umar, in the interest of time, so your sort of concluding thoughts on, how do you sort of see addressing competition concerns in digital markets, be it from the perspective of Mexico or what is happening across the globe?
Sure. So to conclude, I mean, this less restrictive regulatory framework, and the greater the incentive for businesses to innovate and implement emerging in tech like AI, for example. I mean, this enables them to offer a variety of services that and might benefit consumers end of the day. So I mean, we see that, yes, new technologies require regulation, regulatory framework centered on ethics, human rights, transparency, security, of course, competition, innovation. So we have to understand this, and that both the technology and the needs of the stakeholders will help design appropriate regulations and foster competition conditions that we'll want to benefit society as a whole, consumers, also the markets, to have them or make them work properly. And seeing it on a larger scale, like the big picture, I mean, we see that in a world where technology advances rapidly, the challenge for competition authorities is huge. We must be vigilant in preventing these abuses of power while remaining flexible enough to not stifle innovation. I mean, collaboration will be key among institutions. It's critical, more critical than ever, not only to ensure effective and fair regulations, but also to guarantee technological advancements to continue benefiting society as a whole. So I will let it like that. Thanks so much.
Yeah. Reinhold, your concluding thoughts in the background of what is happening in the US. Ben has already has given details what is happening in the EU. How to sort of address the sort of perceived concerns in digital markets.
Renaud, also just to add one more question to your concluding remarks, could you also tell me what do you think of the fact that Google was not even accused of using Chrome to maintain its search dominance? In spite of that, the disinvestment came with Chrome, and that too for 5 years. What do you think? Um, what is your take on it?
Yeah, I mean, very good questions. I mean, circling back to the whole theme of this discussion today with the remedial phase, I think, and I agree in theory with Shiva that there are behavioral remedies that could, in principle, work and like data sharing, but I think there also is the question how this is working in practice, and there have been anecdotes that this data sharing doesn't work as intended at times, and so structural remedies shouldn't be off the table, in my opinion. And given that, and also the DOJ case where somewhat Chrome is somewhat also enforcing Google's dominance in search and ads by serving as a default gateway, so it can also steer users, as I mentioned before. So given that, it's really a huge part of this ecosystem and a gateway and an access point. And like my colleague Paul Heid, who's in co-authors, also show like a theory of harm of ecosystems, specifically because there are access points that are vital for this kind of steering, and Chrome has a very vital position. And I think that's why also Chrome is somewhat chosen as one of these access points to this leveraging market power that Google has. And so the idea would be then to limit some of these access points and to limit some of the ramifications based on that. I mean, the question is then whether this structural remedy is already enough, or whether there should be also behavioral remedies complementing the structural remedy. But I guess this is also beyond the scope now of my concluding thoughts that I have. So thank you very much.
Yeah. Nikita, do you want to conclude, or should I do that?
Please go ahead.
Yeah. All right. Thank you so much, Ben, Shiva, Umar, and Reinhold for accepting our invitation. I think this conversation is just the very start of, I mean, what is yet to happen over the next years. I think we discussed in detail what is happening in the European Union through the Digital Markets Act. We also looked into the role of economics when it comes to sort of differentiating between brick and mortar and digital economy, and how it can sort of give insights when we are going into the remedial phase. Umar very vividly sort of highlighted the sort of balance which is required between regulation and innovation, and to sort of find that right fit is a question which possibly differs for every jurisdiction. Lastly, I think we also sort of discussed how sort of the behavioral remedies which are being sort of imposed on the big tech companies are sort of not being able to give the desired results. and therefore this is possibly the reason why regulators are now moving towards the structural remedies. I don't think so there are right and wrong answers, and as I think we've already discussed, a lot of things are in the making. But again, thank you everyone. Most importantly, I would like to thank Nikita to agreeing to co-moderate this panel and sort of take the discussion forward. We'll be preparing a memorandum for this discussion, and we'll be sharing with the panelists and with the co-moderator. Thank you so much again, everyone.
Thank you so much, everyone.
Thank you very much.
Thank you so
very
much.
Thank you. Have a good day.
Bye.
Good weekend
Good day.
as well.
Bye-bye.
Ciao.
Good morning from Mexico. See you.
A good evening on the other side.